2017 CF 15684, State v. Nelson, back from our lunch recess. Mr. Nunley, is the state ready to proceed?
We are, Your Honor.
Simmons, defense?
Yes, Your Honor.
Mr. Nelson, you ready?
Yes, Your Honor.
Is everything? Okay. Good counsel approach? All right, Mr. Nunley, is the state ready to proceed?
We're ready, Your Honor.
Ms. Simmons, defense?
Yes, Your Honor.
Mr. Nelson, you ready?
Yes, Your Honor.
Let's bring in the jury, please. All right, good afternoon, members of the jury. Mr. Nunley, is the state acknowledge the jury?
We do, Your Honor.
Simmons, defense?
Yes, Your
Mr.
Honor.
Nelson?
Yes, Your Honor.
All right. Apologize for the delay, ladies and gentlemen. Been trying to deal with a few technical issues. I hope we have them resolved. This is Judge Keith White in Orlando, Florida. Can everyone present hear me through the video conference?
Yes, sir. Yes, sir.
My understanding, is there a notary public present with you?
Yes, sir.
And where is that? If that person could come on screen, just identify themselves and their credentials.
My name is Mary Beth Smith. I'm a legal secretary here in the district attorney's office. Do you need other information?
Are you authorized to administer oaths under the laws of your jurisdiction?
Yes, I am.
Anything from state and defense before I have her administer? All right. All right, if you could please administer the oath to the witness.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Could the witness please state and spell first and last name? We have a court reporter present.
My name is Hanna Geist, HANNAGEIST.
Mr. Nunley?
Good afternoon, ma'am.
Good afternoon, sir.
Since we are by video, I'm going to go even more slowly than normal, okay?
Okay.
First of all, what is your relationship to Jennifer Fulford?
I'm her daughter.
And ma'am, where are you physically located today?
Austin, Texas.
Are you able to travel at this time?
No, sir.
Why are you not able to travel?
I broke my ankle, and I just had surgery last Wednesday.
Okay. Ma'am, have you prepared a written statement about your mother?
Yes, sir.
Would you read that to the ladies and gentlemen of the jury, please, ma'am?
Yes, sir. Right now?
Yes, please.
My mom was my best friend. I mean that in every sense of the phrase. We laughed hard. We talked to each other about everything. We held each other's secrets. We checked in on one another, and everything we did felt like an adventure. We bickered. We cried on each other's shoulder. She taught me how to dance, and we danced all the time. She taught me how to sing, and we sang all the time. We were there for one another, and we loved each other more than we loved ourselves. Because that's who my mom was. She loved in a way that made you feel like you were the only human being on the planet, and that love was truly unconditional. Every Friday night growing up was girls' night. She would grab every pillow and blanket in the house and make the most comfy Ooja Booja pallet for us to lay on. Ooja Booja was my mom's little phrase for everything incredible in this world. Good food, hugs, love, a good song, a fire in the backyard, the blooms on her plants, cuddling with the dogs, a fresh shirt from the dryer on a cold day. All of that could be described with one phrase: Ooja booja. Everyone who knew her used this word, and they knew exactly what it meant and in the context in which to use it. Anyway, on girls' night, she always let me pick the movie. I think because she knew I was mature for my age, she knew that whatever I picked, she would also enjoy. But when I was 12 years old, I picked out a movie called What Dreams May Come. Mom must have either seen it or seen the previews for it. I was a little hesitant about me watching it. And nothing about the movie was really violent or explicit, but the movie was about something her and I had only had very tearful conversations about. The movie was about death. When Mom asked me in the middle of Blockbuster if I knew what the movie was about, I said no, but I really like Robin Williams. And Mom explained that the movie was going to be very sad, that it was about a man who loses his entire family to tragic deaths, and that it might not be something I wanted to see. I was a very emotional child, but I was also very smart and very reasonable. So we ended up getting the movie. And after watching it, I couldn't help but silently cry. I didn't want her to know because I said I could handle it and she trusted my judgment. But eventually I just couldn't hold it in. She stopped the movie and asked me if I was okay. I told her I just couldn't imagine living in a world that she wasn't in, that I didn't know what to do if I had ever lost her. And I was so overwhelmed with the thought of it, I told her I wanted to stop watching the movie because she was right. It was not a movie that I wanted to see. I remember her just immediately pulling me into a huge hug and crying with me while she told me that it was okay to feel scared. She told me it was okay to feel sad. She told me that she was also scared. The movie was making her think about things that she couldn't handle if they happened in reality. But that there we were together, playing on the Ooja Booja palette, and it was just a movie we were watching. I'm right here, baby. I'm not going anywhere. I will be with you until you're old and gray-haired, sitting next to you, sitting next to me on a big front porch in a rocking chair, watching all of your grandchildren play. When I laughed about the word grandchildren and started wiping my tears away, she said, "What? You don't believe me? You just watch. I will be a great grandma. I will live so long you'll be tired of me being around. I'm telling you, baby, I'm not going anywhere for a long, long time." She had this way of talking to you and looking you in the eye. The words could feel like a blanket wrapping you up in comfort and love. I felt so relieved in that moment. I told her she could always live with me. I would take care of her for the rest of her life. I would buy her a house right next to mine. And when she couldn't take care of herself anymore, I would be there for her like she was for me. I would make sure that she was okay. We watched the rest of the movie, and every year from then on, we watched it again. You know, she told me the same things as I got older, too. When life got more real, scarier, I grew from a child into a young adult and into my friends passed away. She moved to Florida so she could take care of my sick grandfather. We lost family members. She would always comfort me with the same words. "I'm right here, baby. I'm not going anywhere. I'll be with you until you're old and gray-haired, sitting next to me on a big front porch in a rocking chair, watching all of your grandchildren play." It always, without fail, made me feel better because I knew it was true. I could see it in my mind when I closed my eyes. There was nothing I wanted more. But my mom never got to see me turn 30 years old. She will never dance with me at my wedding. We will never sing another song together. She won't be there for the birth of my children, and they will never know her vast love and the soothing sound of her voice. I will never see the wrinkles on her face or curl her silver hair for her because her hands have aged. I will live the rest of my life without having my biggest supporter there to cheer me on and lift me up. To put a loss like this into words feels like a disservice to the absolute best human being I have ever known. It's a tragedy. It's foreign. It's a language that I don't know how to speak. It was never supposed to be this way. So I will hold on to the voicemails of her singing me songs like I just called to say I love you. I will keep calling her phone just to hear her voice message tell me, I hope you have a wonderful day. I will keep falling asleep every night, hoping that she's there. And the memories are many, and they are all I have left.
Ms. Geist, thank you.
Thank you.
Simmons. All right, Ms. Geist, we are going to disconnect. You're excused at this point.
Thank you.
Thank you. Can council approach? All right, members of the jury, in just a moment, we're going to take a brief recess. During the recess, you are going to continue to leave your notepads and your pens here. During the recess, you're under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. Please follow the deputy in the jury room. We'll bring you back as quickly as we can. Thank you. All right, Mr. Nunnally, the next witness that the state intends to call is who?
Austin Geist, and Ms. Hicks is having this.
Okay, I'm sorry. So that, okay. That's going to be by video?
Yes, sir.
Okay. All right, so my understanding then, Ms. Moore, is you did not have, that's just the highlighted statement that you provided me without the motion, correct?
That's correct, Judge. We received that one this morning.
All right, so go ahead, Ms. Moore.
So, Judge, there were three portions of this impact statement that we're asking to have redacted. The first portion is a few sentences on the first page that begin with, at one point, my wife shared a story, and continues on until, I think the last phrase is, I'm going to wear my I Love Texas shirt. I don't have it all printed in front of me, but I know the court has it highlighted. Our position is that this is not a reference to the uniqueness of the individual or the loss to the community, which is what a victim impact statement has to be limited to. Instead, it's an overly emotional anecdote that is unrelated to the purpose of victim impact statement. If the court did not want to redact the entirety of that, we would ask that the court redact the portion that starts with something along the lines of judging from watching the video, where at that point it says, judging from the video footage at her dentist appointment, this sweet shirt was the last shirt she ever wore. Continuing to, we both believe it, likely she woke up that morning so excited to be heading to Texas with the next day to meet her brand new grandbaby, and she thought, I'm going to wear my I Love Texas t-shirt. That in particular is a statement or opinion about the facts or what happened in this case, which I believe is particularly excluded under this statute, where in a statute it says that it is improper for any characterizations or opinions about the crime and or defendant be included in a victim impact statement. So if the court wasn't inclined to exclude the entirety of that section, we would ask the court to exclude starting at that judging statement. The next two statements.
Let's take them one by
Okay.
one. Ms. Hicks?
This Judge, one second. Judge, pursuant to Florida Statute 921.141 subsection 8, that details exactly what is permissible pursuant to a victim impact evidence. The prosecution may introduce and subsequently argue victim impact evidence to the jury. Such evidence shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death. Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of victim impact evidence. So with respect to this passage that we're talking about, which I believe Your Honor has a copy of it in front of you, okay, and it starts, the highlighted portion starts at one point, and then it goes down for several lines, and it ends with the quote, "I'm going to wear my Love Texas shirt." First of all, there's a passage in there, or a sentence in there that starts with judging from the video footage.
Right?
Okay, so that sentence, judging from the video footage at her dentist appointment, this sweet shirt was the last shirt she ever wore. The state would agree that that should be taken out of the victim impact statement. So we don't we don't disagree that that should be taken out. So, however, the rest of it, it is the state's position that that does not in any way violate the victim impact evidence. It is not a characterization or an opinion about the crime. It is not, doesn't obviously in any way speak to the defendant. It doesn't talk about the appropriateness of the sentence. It doesn't, it isn't overly emotional. It's simply telling a story about the victim, much like we see in the high majority of victim impact statements. Obviously, the defense has a particular issue with this particular story, given the fact that he's clearly describing the shirt that she was wearing that day, but that's a fact that, you know, it's a story about her. It is not overly emotional. And so the state doesn't see any reason why that would need to be taken out. With respect to the entirety of this argument, which would apply to not only this passage or the other passages that the defense.
Well, let's hold off on the other passages. Anything
But I'm
this one?
That's what I'm just saying. I'm going to talk about some case law. My case law would apply to basically my argument with respect to any of these passages. If the court would look at the case of Jordan v. State, which is 176 Southern 3rd 920, specifically pages 932 to 934. This is a Florida Supreme Court decision involving the death penalty and victim impact statement in a death penalty case. It's a Florida Supreme Court decision from 2015, and I apologize for not having copies printed out. This issue just came up this morning. So in this case, the victim impact statement, there was the relevant portions that were read to the jury. It was difficult to watch my father struggle for his last breath. I begged him to let go when he was taken off life support. And then several passages, but it's not fair that my dad wouldn't be there for my first car, my prom, my graduation, walking me down the aisle, giving me hugs. And so these are just different passages. It was not just my father that was taking me from a large piece of what was supposed to be some of the happiest years of my life. But that one in particular, where it was difficult to watch my father struggle for his last breath. It's not that I don't believe that the victim impact statement isn't allowed to reference the day that the event occurred. It's that it can't characterize the evidence. It can't address what the evidence was or what the type of proof was, and it can't obviously reference the defendant, him or herself. The other
Ms.
case.
Hicks, let me ask you, since you agree that the sentence starting with the word judging and ending with the word war is removed,
Yes.
then why shouldn't the following sentence be removed as well? Because it clearly refers back to in the context of the sentence that you agree to be removed. So if it's not removed, it's going to be out of context.
And I believe the jury can certainly, these people were strangers to her, but she found the fundraiser online and purchased a shirt to support them. We believe it likely she woke up that morning so excited to be heading to Texas. Obviously, the jury knows what shirt they're talking about, Judge. The jury has seen the picture several times. And so I don't agree that it refers back to that. Judging from the video footage at her dentist appointment, that does reference a specific piece of evidence that was there was I don't know if Your Honor is aware, but the still shot photo was taken from the video. So judging from the video footage at her dentist appointment, the jury doesn't know about the video footage, but they know about the single photograph that was taken during that. This sweet shirt was the last shirt she ever wore. I think arguably this sweet shirt was the last shirt she ever wore. Arguably, I think that is admissible, but we'll agree to that coming out. But the specific reference to a fact in this case, or particularly a piece of evidence that didn't actually even come into evidence, that should be taken out. But I don't believe the jury will have any contextual issue with, we believe it likely she wore that morning, excited to be heading to Texas. The jury has heard that she was to be heading to Texas the next day. I just think that
Ms. Hicks, I'm sorry,
Sure.
we have a couple more things. Brief reply, Ms. Moore, just as to this first highlighted portion.
Yes, Judge, the statute is very clear that opinions about the crime are to be excluded, particularly the line that says, "We believe she thought these things," I believe is an opinion as to the facts and circumstances of the crime. And so that's why we're asking to redact that as well.
All right, with respect to this first highlighted portion, the court's ruling would be as follows. With respect to the portion starting with the word "at" and continuing all the way down to the word "them," that immediately precedes the word "judging," that first part of the highlighted portion, the motion would be denied. The motion will be granted starting with the word "judging" and then ending with the word "shirt!" the last portion highlighted of this first portion. That would be granted. All right, Ms. Moore, going to the next, on that same page, down at the bottom.
Correct, Judge. I have that part of it. Thank you. So, Judge, this phrase, or a couple of sentences, we believe is a characterization of the crime, that particularly characterizing the crime in reference to the timing of the child's birth, we believe is unduly prejudicial. Because it's a characterization and then also an overly emotional characterization, that's our objection at this point. And so we would ask that it be redacted, starting from "there are no words" until, I believe, 3 sentences later, when it ends, "hospital 3 days later."
Ms. Hicks?
Judge, in another Florida Supreme Court decision, and then it's KALISZ v. State, 124 Southern 3rd, 185, Florida Supreme Court decision dealing with the victim impact statement in a death penalty case from 2013. The victim, the homicide survivor, was permitted to describe that she had received a birthday card and a gift in the mail from her mother the day after she died, and talked about how her mother was killed the day before her birthday. And then another victim in that case addressed that another homicide survivor addressed that the victim would never be a grandmother or be able to hold her grandchildren. The court allowed both of those statements. They were not overly emotional, did not mention the defendant. They did not implore the jury to impose the death penalty or seek revenge for their mother's death. The whole point of a victim impact statement is to talk about how the victims are impacted by the loss of the homicide victim. It is a fact in this case that these people, their child was born on the day she died. And that is not just because that is a fact, that is how they're being impacted by it. They will have to, for the rest of their child's life, recognize that his mother was killed on the day his child was born. that is how one of the probably most significant impacts it will have on him. And this does not mention the facts of the case. It is not a comment on the evidence. It is talking about how he felt given the fact that his child was born on the day his mother was killed, and that they will have to celebrate her birthday. And that's what they are choosing to focus on, is celebrating their child rather than always remembering that that is also a dark day.
What about the last sentence?
Her body was found within minutes of us arriving home from the hospital.
Right, I understand your argument with respect to the other two, but what about that?
That's a fact to them. That's how this impacted them. It's not discussing the facts of the case. To them, that's what happened to them, how they learned about this. Because obviously we're dealing with a situation where she was missing for 3 days, and now she's found 3 days later. What the emotional impact of that to them on the day that their mother was found.
Ms. Moore?
Judge, I don't believe that I have any further argument at this point, other than that I do believe it's a characterization which is specifically excluded under the statute. And this phrasing or sentences is not talking about impact, it's giving facts in a characterized way.
All right, with respect to this aspect of the defense motion, starting with the word there, and then continuing all the way through to the word later at the bottom of the page, the defense motion will be denied.
And Judge, the final portion, as to this statement, is on the last page, and it begins with "we will continue," ends with "blessed to have." Again, it's our position that this is improper. This is not about the uniqueness of the individual or the loss to the community. I imagine it could be rephrased in a way that said that it expressed a loss to the community, but that's not how it is written. Instead, it's specifically about the grandchild and her alone. And so at this point, we don't believe it's appropriate.
Ms. Hicks?
Relying on the argument that I made for the last section, Judge, it is commenting just because my family was impacted in ways that most people can't fathom. We will choose to celebrate. This obviously refers back to the fact that she died on the day this child was born, and that is part of the emotional impact to them. It's ironic that they leave out the fact that the defense doesn't want them to put in the fact that she was murdered on the day that the child was born, and so they've previously asked for that piece of it to be excised out, and now they're saying that because there's not a specific reference to the fact that the child was born on the day that she died, that this section has to come out. This is them expressing how they are dealing with the loss of their mother. They're dealing with it by celebrating their child instead of the horrible thing that happened that day.
But how does that relate back to the statutory language in terms of the loss to the community's members? This particular statement, as it's worded.
Because how it's impacting them, the loss to the community, which is, they are obviously part of the community, how it is impacting them is, the day is different for them. And they have to, the day of their child's birth would obviously be a very different day, but this is how they have to deal with it without her being there.
Okay. Ms. Moore?
Judge, I don't have any further argument. It's just as phrased, we don't believe it relates back to the statute's requirements.
And I would just note, it's a continuation of the part that, this section that Your Honor just ruled was going to be admissible, which is there are no words for the darkness. This is all a continuation of that.
With respect to this particular statement as phrased, I'm going to grant the defense motion, starting with the word "we" and ending with the word "have."
And that's where I'll be.
That one sentence. All right, is the Good counsel approach.
Hey,
Hi, can you hear us?
yes, they're printing out the edited statement. So you can give us just a minute. Mhm.
Yes.
Judge, I believe we're ready to proceed. Just so your honor's aware, I'm going to have to stand back here because the audio for them to be able to hear me is going through this computer as opposed to the microphones in the courtroom. If that's okay with your honor.
Yes, can you hear me now? Yes.
That's fine. The only thing, if defense is going to have questions, you may have to move it up to the lectern so that,
I don't believe it's going to be an issue, your honor.
okay. All right, Ms. Hicks, is the state ready to proceed?
Yes.
Simmons, defense?
Yes, sir.
Mr. Nelson? Yes, sir. All right, let's bring in the jury, please.
Will you ask them if they judge here to do anything?
Just use this one.
Did she send a different?
She sent out the wrong one. She sent the wrong one. Okay.
You guys okay?
I'm just, yeah, she had sent us statement to print off, so I'm just going to read it on the phone.
Okay, make sure you take out the stuff that had to be taken out, okay?
Hold
Hold on.
on, sir.
It looks,
If you need time. No, it's still on.
it's,
Tell them. I was telling them that you need.
she's,
no.
Nope.
is this it? Is this that? Okay, is this edited? Okay.
I say for. You ask. Can you hear our
Ms. Hicks,
judge?
excuse me, hold on one moment, please. Ms. Hicks, does the state acknowledge the jury?
Yes, your honor.
Ms. Simmons, defense? Mr. Nelson? All right, members of the jury, with respect to the previous witness, you have heard evidence about the impact of this murder on the community of Jennifer Fulford. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Jennifer Fulford's death. However, you may not consider this evidence as an aggravating factor. With respect to the witnesses who are about to be called, you are about to hear evidence about the impact of this murder on the community of Jennifer Fulford. This evidence is being presented to show the victim's uniqueness as an individual and the resultant loss by Jennifer Fulford's death. However, you may not consider this evidence as an aggravating factor.
Your honor, I just have one moment.
Yes. All right.
Asked to speak to anybody, so I don't know. Okay. Whatever they want to do.
All right, good afternoon. This is Judge Keith White in Orlando, Florida. It's my understanding that someone is present who is authorized to administer oaths to the witnesses. If that person could please come on camera and identify yourself.
Okay. Am I on camera now?
Good afternoon. Yes. Could you please identify
Good afternoon.
yourself?
My name is Margaret Barnes, and I'm judge. I'm a judge here in the state of Texas, and I am authorized to administer oaths. I have identified the witness, Lindsay Austin Geist by his Texas driver's license. And when you are ready, I will administer the oath for him to give testimony.
All right, good afternoon, Judge. Yes, please administer the oath.
All right? And ask Mr. Geist if you please stand and raise your right hand. Do you solemnly swear that the testimony you give will be the truth and nothing but the truth? So help you God. Thank you. You can have a seat. All right, thank you all very much.
Is the other person going to?
I believe she's not going to speak.
Okay. All right, Ms. Hicks? Yes.
Want the actual
People in Texas, if you could please just refrain. I'm sorry, you may not be able to see us, but thank you. Good afternoon, Judge.
Good afternoon. Do you want to come closer to the microphone? Well, you don't have to, your choice. Yeah, are they just going to hear me? They're only going to hear you here. I don't know how portable. If you can talk loud enough from right there and see whether or not they can hear you well. Then
Yeah, you need to be seated so we can see you, and just bring whatever microphone for the phone as close to you as possible.
Okay.
You currently hear me?
Yeah. Can we transfer that phone call to this phone? You're going to try to do it, and then I'll be right here.
Can you hear me?
All right, Mr. Geist, if you could please state and spell your first and last name for our court reporter who is present here in Orlando, Florida.
Austin Geist, AUSTINGEIST.
Thank you, Mr. Geist. We're getting some sort of a feedback.
I apologize.
Ms. Hicks?
Thank you, Your Honor. Good afternoon, sir. Can you hear me?
Yes.
All right. Could you please tell us who is the...
I'm sorry. Give me.
Hold on, I'm going to mute this one.
We're. Okay. Okay. Can we try that again, please?
Can you hear me now?
Yes.
All right. And do you have any feedback on your end?
No, I think that might have resolved the issue.
Okay, great. So if you could start out by telling our jury, how are you related to Jennifer Fulford?
I'm her son.
All right. And can you tell us who the young lady is sitting next to you?
This is my wife, Laurel.
Okay. And where are the two of you located today?
Denton, Texas.
Okay. And are you unable to travel here to Orlando?
Yes, my wife is currently carrying our third child. We've got a 4-year-old, a 1-year-old, and we couldn't find it. It was too difficult to try to coordinate a time to get over there. When we were informed that we could Skype, we decided to go that route.
Okay, sure. So did you prepare a statement that you wanted to read to the jury?
I did.
You could please read that to the jury.
Okay. Here are some words from both my wife and I. My mom had this uncanny ability to find joy in everything she did. She lived life to the fullest and loved fiercely, no matter what the circumstance. A characteristic of a strong individual. Life can be very difficult at times, but she took it on the chin and kept on singing. She never pointed the finger at other people or blamed others for their circumstances she faced. I can still hear my mom singing Barbra Streisand at the top of her lungs, whether it was Friday night after work or Sunday morning at 8 a.m. while cleaning the house. She was full of life, so giving and thoughtful. She talked to everyone when we'd go out shopping or run errands. Conversations on the phone were always at least an hour. She'd listen to people's stories, absorb them, and share them. She loved to be needed and thrived on helping and caring for others. At one point, my wife shared a story with my mom about a couple of friends that had been unable to conceive a child, and they were going through the expensive process of adoption. They were having a fundraiser, and if you purchased the shirts, the proceeds went to helping them raise money to adopt. It was a shirt that said love on it, and the O was in the shape of Texas. These people were strangers to her, but she found the fundraiser online and purchased the shirt to support them. My mom had so much love in her, oftentimes the word love itself didn't express the kind of affection she wanted you to feel. She would make up words like ooja booja that were meant to encompass all of the feelings, affections, hugs, and kisses that come with loving someone. She'd use ooja booja all the time. I recall mornings waking up to her, playing music and singing in my kitchen while she cooked all of us breakfast before we got up. She loved sitting on the patio and talking for hours about life, beliefs, faith, and reminiscing and telling stories. The depth of her loss is difficult to put into words. My mom was the best mom, a wife, a sister, an aunt, a friend, a grandma. All these people feel her absence daily. Like a deafening siren that never ceases. She loved her family with a fierceness, and her family included not only those by blood, but her friends, her children's friends, her friends' children, and all of Reed's family as well. There are no words for the darkness surrounding the timing of all this. She went missing before our daughter was born and was ultimately murdered the same day. Her body was found within minutes of us arriving home from the hospital 3 days later. My family was impacted in ways that most people couldn't fathom, and we will choose to celebrate this amazing mom's life as well as her incredible legacy that will spread for generations and the faces of her children, her children's children, and so forth. She is no longer here in the physical form, but I know she is out there dancing and singing with a smile on her face and love in her heart. I promise you this, she is the one who will be remembered.
Thank you, Mr. Geist.
Simmons. All right, Mr. Geist, we are going to disconnect now.
Thank you.
In just a moment, we're going to take a brief recess. During the recess, you're under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. That includes but is not limited to discussing anything at all related to this case. You're going to continue to leave your notepads and your pens on your seats. Please follow the deputy in the jury room. We'll bring you back as quickly as we can. Thank you. All right, Ms. Moore, so the defense motion related to Ms. Wilczynski?
Yes, Judge.
Okay, go ahead.
Yes, Judge, there were 4 passages that we were asking to redact from this statement. They are quoted in my motion. So starting with passage 1 that is quoted in paragraph 5 of my motion, which begins, I thought, and ends, nights. Our argument as to this passage is that this is a characterization of the crime. It goes into the facts and circumstances of what happened, as well as the witness's opinion about that.
Mr. Nunley?
Judge, that statement is no more than the witness's reaction to the fact that her best friend did not answer the phone when she expected that she would. That's not a characterization and opinion about the crime, the defendant, or the appropriate sentence. There's nothing improper about that. It's merely a statement of fact.
But how does that fall within the scope of what's provided in the statute in terms of what victim impact evidence is?
In the context of the paragraph, Judge, it's talking about plans that they were making, plans now that are derailed or not going to come to fruition because of the victim's death at the hands of the defendant.
And I apologize for interrupting, Mr. Nunley. I don't have the entire statement. I just have the motion.
I apologize, Judge, I forgot that I hadn't provided.
If I can approach, Your Honor?
Yes.
The first
Thank
one,
you.
Judge, is the third statement in the last paragraph on page 1 of the statement. I thought it was strange when Jim did not pick up the phone that Wednesday.
Okay, I have it. All right, Ms. Moore, reply with respect to passage 1.
Yes, Judge, just the fact that she's talking about her thoughts and perceptions of the facts means that it's an opinion as to the crime and characterization, and that is our objection. It doesn't fit within the allowable categories of victim impact and is part of what is supposed to be excluded.
All right, with respect to passage 1, the motion will be denied. Okay, going on to passage 2, Ms. Moore?
Yes, Judge, this is similar in context and in statement, and so our argument is the same. It's again talking about the witnesses' opinions about what the facts or circumstances of the situation were, and so we believe it's specifically excluded under the statute.
And which, could you refer me to, is it on page 1 or page 2?
That's on page 2, the bottom of the first full paragraph of page 2.
Give me a moment. All right, Mr. Nunley?
Your Honor, as to that paragraph, that second identified statement, the state's argument is basically the same. It is a statement of intent. It is not a statement. It is a characterization and opinion about the crime, the defendant, or the appropriate sentence. It is merely a statement of fact that this witness is entitled to certain to make. It is not prejudicial. It is not inappropriate. It falls within the purview of proper victim impact evidence.
More?
It's just that specifically the more than unlike her, it would never happen is very clearly an opinion and improper under the statute.
All right, with respect to passage 2, the defense motion will be denied.
And then passage 3, this is a characterization of the crime.
I'm sorry, Ms. Moore, where is that?
I apologize, it's the last couple of sentences of the second full paragraph on page 2.
Okay, go ahead.
That this is, again, a characterization of the crime. It also is not about the uniqueness of the individual or the loss to the community. It's an overly emotional statement that is improper and unduly prejudicial.
Mr. Nunley?
Judge, this is, and I'm quoting from Victorino v. State, 127 Southern 3rd, 478 at 496, a death penalty case from the Florida Supreme Court in 2013, that says, evidence of grief and suffering due to the loss of the victim is evidence of the, quote, resultant loss to the community's members by the victim's death, close quote, and therefore admissible victim impact evidence. That is exactly what this is, and it is admissible under Victorino. There's a subsequent case citing Victorino, Cozzie, C-O-Z-Z-I-E versus State, 225 Southern 3rd, 717, 730 is the pinpoint site. This statement of these two sentences are not inappropriate. They are within the scope of allowable victim impact testimony, and they should be allowed.
Ms. Moore?
Yes, Judge, these sentences specifically refer to Mr. Nelson, not by name, but why would he do this? Why would you, in particular, take her away from me? That particularly is inappropriate, that they're referring to the defendant directly. She's apparently asking him a direct question, which would certainly be inappropriate. If the court were not going to grant the motion as to all of it, we would ask that the court at least redact the last two sentences, but we do believe that all of it is inappropriate.
Mr. Nunley, what's your response with respect to this reference to the defendant in the last two questions of this statement?
I would agree to removing the sentence or the question, why would he do this?
And what about why would you, that reference to the defendant?
I do not believe that to be an appropriate reference. I do not agree to redacting that portion of the statement.
with respect to passage 3, that's going to be with respect to the sentence starting my later days, ending with questions. Motion would be denied. Why did this happen to her? Motion would be denied. It will be granted with respect to the last 2 questions in that paragraph. All right, passage 4.
Yes, and that's in the middle of the last full paragraph, Judge. This one is very, very directly a characterization of the crime and of the defendant, specifically uses the word murderer, and robbing the world is clearly a characterization. So we would ask that that be redacted.
Judge, I would agree to changing that sentence to read, to use the language used by the witness that Jen's murder robbed the world, et cetera, et cetera. That is a direct statement of impact to the community. I will take out the phrase, this murderer, and replace it with Jen's murder.
Ms. Moore?
Judge, we would still object to using the term robbed. We believe that that's a characterization of the crime, which is inappropriate under the statute. I think that there are ways to phrase it, perhaps that we lost a best friend and continue from there. But I do believe that using the word robbed is a characterization of the crime, which is clearly inappropriate under the statute.
Only
I don't think.
just reply with term as far as using the term robbed.
I don't see an issue with that, Your Honor. I think it's a way, it's a manner of speaking. It's not a technical legal term that she's using. It's the way, it's merely her language that she is using to express what she is trying to verbalize and put on paper for the jury.
All right. And so how was the state acknowledge that you would delete this murderer and replace it with what?
Jen apostrophe S murder.
Is that how this particular witness refers to Ms. Fulford?
Yes, sir.
You agree with that defense, that that's how this witness refers to her?
I believe that she refers to her as Jen throughout the rest of the statement, yes.
Okay. All right, so the motion will be granted with respect to the words "this murderer." That will be replaced with Jen's murder. Otherwise, the motion will be denied with respect to passage 4.
And just to make sure our position was clear, that I wasn't agreeing to the state just replacing that portion. We are still objecting to the word robbed.
Sure, I understand.
And those were the only passages that were in that statement.
All right, so in a moment, we're going to take a brief recess, and then we will come back and continue the presentation of the evidence in front of the jury. Be in a brief recess.